Yes, so as the chair mentioned, I am the director of a charity based in the United States, but working in over 50 countries around the world now for the past 11 years. I'm here in a personal capacity today, and really I'm here as a researcher. My area of research has historically been on treatments and the prevention of eating disorders, but last year it took a turn, and I, along with my co-author, Dr. Catherine Cook-Catone, completed what's called a systematic review. And that was a systematic review of assisted death in eating disorders. And our findings really shocked me. We found that at least 60 people around the world have been euthanized or assisted in suicide. I'm using jurisdiction-specific terminology there. I will use assisted death and assisted dying today. And that includes in 3 jurisdictions in the United States, where I'm from, in Colorado, California, and Oregon. And that's important for the committee because those are jurisdictions where assisted death is legally restricted to terminal conditions. So we saw anorexia listed by name, anorexia nervosa listed by name as a terminal condition, and most alarmingly to me, in 2 of the states, we could not find any mention of documented cases in the annual state reports. So had a physician and her colleagues not written a paper and told the world about it, we would not know that those young women had died. 100% of the cases we reviewed were women. A third were between the ages of 18 and 30. 2/3 were under the age of 40, and I have to emphasize these were young women that did not have failing organs, did not have comorbid terminal conditions. Zero of the cases we reviewed was their organ failure or comorbid conditions, and they had decades of life ahead of them. So I hope that I can be helpful to the committee in sharing the evidence that we've uncovered internationally. I think most relevant, this evidence is most relevant to Clause 2, the definition of terminal illness, and Clause 3, mental capacity, but also relevant to latter stages, parts of the bill on reporting and on the substances, the approved substances used for this process. So thank you.
I'm going to have to urge brevity on everybody this morning because of the length of time we haven't got. Yogi Amin, please.
Morning. Thank you for having me. So I'm Yogi Amin. I'm a partner at Irwin Mitchell Solicitors, where I head up the Public Law and Human Rights Department, and I've worked in the area of mental capacity law and public law for over 20 years, which includes cases where there's disputes over medical treatment and safeguarding aspects. I've put a written note in to the committee this morning. I'm sorry it's late, but it's arrived just before I arrived, so I can touch upon some of the points in there. I should say that the evidence I give and the information I've given is in a personal capacity and should not be attributed to my employment or any organisation I'm in, because I'm also a trustee of the Royal MENCAP Society. And I should also say I'm a Law Society accredited legal representative, which means that as part of my practice, I represent people who are vulnerable, who come before the Court of Protection for decisions about disputes on mental capacity and best interests.
Finally, Professor Shakespeare, please.
Thank you very much for inviting me. As you say, my name is Tom Shakespeare. I'm Professor of Disability Research at London School of Hygiene and Tropical Medicine. I'm a sociologist. I've done considerable research, qualitative research with disabled people. I think I'm here to say that most disabled people support the bill. There are some very vocal people who oppose it, and they have every right to do so, but this bill is supported by disabled people. I think that it's supported because it's restricted to terminal illness, which I think is a very good thing. I think I would oppose the bill, which is actually relevant to all disabled people. This is only relevant to people who are dying already. And it defines terminal illness very clearly. Mental illness, for example, cannot be the sole criterion, so that would rule out people who have eating disorders, I think. I don't think that, obviously we live in a difficult world and there's a lack of social support. I would like to see better palliative care, more hospices and more options for disabled people and people who have terminal illnesses. But I think this should be a tool in the toolbox for people who have terminal illness. They may not select it, but knowing it's there will give them a sort of insurance that they will face death knowing that they have a way out, quicker, better death if they choose that. Most won't, some will, and they should have that right. Thank you.
Thank you very much. Jake Richards was not called during the last session, so Jake Richards, please.
Thank you for those introductory statements. If I made a question for Mr. Amin regarding the current operation of the Mental Capacity Act and how the court protection approaches that issue. Obviously, the bill as drafted currently essentially defers to the Mental Capacity Act in terms of that, and I just wondered whether you have any reservations about that or any thoughts that you could offer the committee.
So reservations, no. In fact, I wholly recommend and support the idea as drafted to defer to the Mental Capacity Act for capacity assessments. I mean, I've been working in this area for over 20 years, both before and after the Mental Capacity Act came in, and have done cases all the way up to the Supreme Court and day to day in cases around the country, and it's well understood how capacity assessments are done, and it's ingrained into the practice of both practitioners generally and legal practitioners in the courts, and certainly when I give training to advocates or to doctors, etc., it is well understood how to apply the test, and that could then just be adapted for this particular decision, which is done here. We've had a decision in the Supreme Court in the last couple of years which has settled how to approach the question of capacity, and so really to disturb that would concern me.
Just to be clear, it would concern you because it would cause confusion, or?
Well, it's a well settled and understood approach to the law, and producing a new one would throw up a whole new conundrum where people would be questioning how to approach it, etc. It's not broken, is what I would say, so it works well.
That was a specific question to Mr. Irwin, but it's an important issue. Does anybody else wish to come in particularly? Briefly, please.
Sure.
Thank you.
One thing I'd like to highlight in our study is that all 60 people who died, young women mostly, were found to have mental capacity to make the decision to end their life. So I worry that mental capacity will not be an effective safeguard to prevent people with eating disorders from qualifying under this bill. I would also note Oregon and California, where I'm from and where we've actually found cases, have an additional safeguard to mental capacity. And that is, if there are any indications that the person might have a mental disorder, that person must be referred for a mental health assessment. So it's important not to make a false equivalence between mental capacity and mental health. So we could have a person, for instance, who has a 6-month or less prognosis, but their wish to die is emerging from severe depression, from suicidality. And we saw very high rates of suicidality and depression, 89% depressed, and nearly half were chronically suicidal when they died. And that it was, physicians emphasized still that the wish to die was not emerging from a mental illness, despite them having diagnosed mental illness.
Rebecca Paul.
Thank you, Chair. My question is to Chelsea Roff. Firstly, I just want to thank you for your written evidence, which I found extremely helpful. It indicates that in Oregon, California and Colorado, patients with anorexia have qualified as having a terminal illness. There have been instances where patients suffering with anorexia have been described as terminal and treatment withdrawn in the UK itself. Is it accurate in your view to regard these young women as suffering with a terminal illness, and what changes to the bill would you suggest to better protect them?
Thank you for that question. No, I do not think it's accurate, but I have to emphasize that laws in other countries have expanded through clinical interpretation, not just legislative amendments. So there are clinicians, a very small minority, who disagree and have characterized anorexia by name as a terminal illness, but they have also said that eating disorders qualify because of the physical manifestation of the disorder. You can't disentangle a mental disorder from its physical effects. So they cite terminal malnutrition. We've identified 25 cases between California and Colorado where malnutrition was listed as the terminal condition. I can't rule out if that was anorexia or something like voluntary stopping of eating and drinking, but I worry that it's the physical manifestations that will be cited, and without a mental health safeguard in this bill, that puts a whole lot of people at risk.
Thank you. Dr. Griffiths or Professor Shakespeare, do either of you wish to comment, as you haven't spoken yet?
I would say that if you look at Section 2, the definition of terminal illness is very clear. The person not to be considered to be terminally ill by reason of having one or both either a mental disorder or a disability. So I think that would cover that case.
May I, Chair? Just one sentence. I think you've left out an operative word in that sentence, which is only. So a person is not considered by terminally ill by reason only.
Thank you. Mary Tidwell.
Thank you. And just to clarify, that word is in subsection 3. So just for Professor Thomas Shakespeare to start with, and then if I may, I want to follow up with Dr. Myra Griffiths. Tom, why is it so important that disabled people have a choice? I made it very clear when I voted at the second reading that I would only do so because this bill was not about intolerable suffering, but was limited to 6 months terminality. So can you just expand on that point, please? And any research that's been done in jurisdictions where equivalent legislation is now in place from the perspective of disabled people, please?
I would say that it's very important that it's for terminal illness only, that should give a sense of safety to disabled people. There are, in jurisdictions like Oregon and California and Montana that Chelsea's mentioned, we have not had an extension, not had an expansion from terminal illness to, as it were, suffering. If you don't carry suffering in the bill, you will not get, I think, into the situation that Canada got into. I gave evidence because Canada was seeking, some people were seeking to expand the coverage of that act to all disabled people. And they did so by referring to the Canadian Charter of Rights and Freedoms and to the word suffering. And they said, look, lots of people are suffering, not just terminally ill people. And therefore it's very important that it's only terminally ill people who are covered by this bill. And that, as I say, should give disabled people some support. We talk about choice and control, as you know, Marie, as being the principles of independent living. Disabled people should have rights over their lives. And this is people who are disabled, yes, but terminally ill primarily, and that's why they should have this law, which gives them choice and control over their lives. They're going to die anyway, but it removes the fear of and the reality of a difficult and unpleasant and undignified death.
Thank you. Dr. Griffiths, do you wish to add to that?
Please, yeah. I think this issue highlights a fundamental flaw with the bill, which is this nonsensical division between a terminal illness and what constitutes being a disabled person. We are aware in the clause 6 of the Equality Act states a disabled person is somebody who has a physical and mental impairment, and an impairment which has a substantial and long-term adverse effect on their ability to carry out day-to-day activities. Now, of course, if you have a terminal illness, it is likely that you will be defined within those terms of what's outlined in clause 6. So it's a fundamental flaw, because disabled people will be incorporated within this. It also highlights this arbitrary nonsense around a 6-month perspective. What constitutes 6 months left to live, particularly if you are engaging with technological devices, with medical assistance and so on. For example, for myself, with a progressive condition which continuously gets weaker and has respiratory complications and so on. If I remove my ventilator, which I use at night, if I remove my medical devices and my engagement with therapeutic services, does that constitute then that I will have a terminal illness? Because my rapid acceleration towards death becomes more evident. So I think that these concerns and these issues highlight fundamental flaws, but they also play into what I think is a key issue, which is the continuation then of campaigning that will continue after, if the bill is to succeed, because then you will get people who will say, well, why not 5 months? Why not 7 months? why not other conditions that are not being highlighted in our current discourses?
Sarah Olney.
Thank you, Chair. Dr. Griffiths, do you think it is possible that disabled people are likely or potentially more at risk of being coerced or otherwise persuaded to seek assisted dying as a result of this bill?
One, because I think the coercion principles outlined in the bill are incredibly weak in terms of the scrutinising and also the process of how you judge whether coercion has taken place. We know coercion is a complex issue, and when you then contextualise that in the context of disabled people's lives, we're talking about disabled people who are struggling in the day-to-day access to sufficient support, struggling to live in participatory and accessible societies. The feeling of then societal coercion to feel that this is a tolerable idea, I think highlights the concerns I have about coercion. But also it plays into this issue around support and assistance to understand what your rights are, not just in terms of what we're talking about here, but broader disabled people's rights. There's a lack of advocacy services available to disabled people. There is a lack of support for disabled people to have accessible information about their rights. So if you feel that assisted dying is your only choice, as opposed to accessing support, accessing and calling out discriminatory practices within, say, access to social care, access to healthcare and so on. This again highlights issues where coercion will manifest, and the infrastructure to support people either to respond to coercion or understand that you don't have to be in that position in the first place is non-existent.
Thank you very much. Sorry, Tom Gordon, please.
One of the things that we've heard from other countries where they have assisted dying is that this is actually one of the strongest and most robust laws. I'm just wondering if Professor Shakespeare, if you had any further views on how we could make it even tighter and provide support and sort of further sort of peace of mind to people who might be worried about this.
When I read the bill, I thought that it did have many safeguards. It has, for example, 5 opportunities for a conversation with doctors or other supporters. So I think that is a good safeguard. I think it makes a criminal offence of dishonesty, coercion or pressure. So I think that will scare off people. And Miro is quite right. There are people who might put influence on somebody. But I hope that they would be covered under Clause 26 as having committed an offence, and that would scare people who may have a particular view against assisted dying. How could we make it stronger? I think maybe having more of an advocate for the person who is requesting assisted dying, somebody who will support them within the law to make that decision or to think about that decision. We're trying to make sure that everybody who is thinking this is for them has the opportunity to talk about it and to think about it. And the time and the conversations are all about that. But maybe an advocate also would be the person who is requesting this death who is not beneficiary in any way of that death, could be a neutral party to give advice. I'm not sure. But there's a lot here. There's 5 conversations. So I think I'm not surprised that people thought it was strong. I think it is a strong act. There is a scope for doctors and other medical practitioners to to act on their conscience and to withdraw from this. I think that Miro may make a useful point that we do not want any disabled person frightened of their doctor or worried that their doctor, who has been supporting somebody else to die, might do that with them. I wonder whether, I think in conversation with Marie, we've talked about a assisted dying service as being a part of the NHS, but specifically around this. I think that is worth considering. Whether your average doctor is the person to whom you should take a concern or a wish to die. So advocacy and maybe having a specific service for people who want to go down that route. But I think it's a strong bill as it stands.
I think just adding on that as well, one of the things that we've heard from other people and other jurisdictions is moving away from a High Court judge and having a multidisciplinary team and panel. Is that something that you think would further strengthen it, and would you support that? I
think law is only one of the influences that might be there. There's also physical health, mental health, and also social well-being. So I think a multidisciplinary panel might be a better way of finding out. But I bow to my friend who's got a lot more experience of legal panels than I have.
Shrameen, do you want to comment?
Well, the way it's drafted, the judges reviewing the case are not making an order, they're declaring a plan that someone else has produced and put in front of him. So it's a strong independent legal judicial safeguard as part of the bill, so I understand that. And my written submission will, you'll note, says that the courts are well used to doing this. The courts have been doing it for many years. They've been dealing with disputes over facts, disputes over capacity, disputes over medical treatment issues. They're able to identify safeguarding issues. So the courts and the judges are certainly able to do it. I'm not speaking to the question of capacity. And if the question is, do you introduce something different from the High Court, then I'll certainly wait to see it and scrutinise it. But as it's drafted at the moment, I would say the High Court judge is a strong legal safeguard as part of the mix of safeguards in the bill.
I'll come back to Marie Tidball again, but can I make it plain to the panel that while questions are being directed specifically to panellists, if anybody wishes to come in on something, do please indicate. Chelsea.
Just to your question, Mr. Gordon, around is this the safest bill in the world? I know there has been due care taken to make that happen. One of my biggest concerns with Clause 2 of this bill is that it makes no distinction between a person whose illness can become terminal if they refuse or cannot access treatment. For instance, someone with diabetes. Type 1 diabetes affects 300,000 people in this country, often co-occurs with eating disorders. And the way this is written would not prevent someone who chooses to stop taking insulin from qualifying as terminal. I will also, last thing, add that in the US, we are seeing voluntary stopping of eating and drinking used to circumvent the terminal illness safeguard. I'm going to quote the American Clinicians Academy on MAID, which is the professional body. Legally, there is nothing in the letter of the law that explicitly prohibits voluntary stopping of eating and drinking as a terminal diagnosis to qualify for assisted dying. They describe this as a legal gray zone that would essentially eliminate the terminal illness criteria. There is nothing in this bill as written that would prevent that. And you have to look at the letter of the bill because it expands their interpretation, not just amendments. Thank you.
Final question, Marie Tidball.
Thank you. And this is directed to Professor Tom Shakespeare and Dr. Miro Griffiths. And one of the amendments I'm backing would establish an advisory council on the impact of the bill on disabled people, because I'm passionate that we monitor the impact, should this pass through Parliament, on that group of people. And I just wondered if you can both reflect on what structure or mechanism you think could work to facilitate this.
So I think this plays into a broader issue around the reporting mechanisms associated with the bill. And I think there needs to be further robust action around how to collect data, how to allow it to be analysed, and then how it allow it to see the trends that are occurring in terms of possibilities of why people may be pursuing this option, but also how that may play into broader political, socio-economic issues, such as a lack of services elsewhere or frustrations with disabled people and their families trying to access particular services. I would encourage that if any advisory council was created, and I think this goes back to a point that was made by Tom, is that you would, whilst we may see popular opinion within disabled people's communities, it is of worthy note that there is no deaf and disabled people's organisation. So these are organisations that are representative of disabled people who engage critically with the issues facing disabled people's communities. None have been in support of this. So therefore I would encourage to have their representation and within any form of advisory council. And I would also request that scholars such as disability studies scholars that are often left out of the discourses around disability policy are also part of any form of mechanism to advise or to scrutinise.
Professor Shakespeare.
Yeah, I think the council is a very good idea. I think it should reflect the range of views, absolutely, as Mira says. What is relevant to me, I think, is that in Oregon, disabled rights advocates have not, as I understand it, opposed the bill that they now have, the act that they have, that disability groups are, of course they're mixed, but some are definitely in favour. So I think there is a difference between organisations, disabled people, and disabled people on this. And certainly that seems to be, so politically, the disability rights community against assisted dying, they always have been. That does not mean that they reflect what ordinary disabled people want. And that's what is important, I think. I think you should be interested in what people want, and they want this.
Sean Woodcock.
Thank you, Jen. My question is to Dr. Griffiths and Chelsea, if I may. We've had 2 days almost of evidence. Yesterday afternoon we had practitioners from the States. This morning we had practitioners from Australia. And the message seemed to be very clear that coercion essentially doesn't happen in voluntary assisted dying. That was the very clear message that they gave. And the message also was that those who went through it were people who wanted to, and it was very appropriate for them, and that there was almost no issues. Can you explain why they're wrong, if you believe that they are?
Well, going back to my previous point around how coercion can manifest in various different ways, and one can be exposed to the societal pressure to feel that your life is no longer tolerable because of the struggles that you have in terms of accessing services, accessing provision, accessing support. We know from data that we have people in the community who are struggling to see their GPs, who are struggling to see their consultants associated with their conditions and changes in their condition. So the coercion, I feel, will come from how society is organised and does not respond to the injustices faced by disabled people. But I also think there's a broad and slightly different issue as well, which is there's nothing in the bill, in my view, that satisfies the concern that when you have, if it was to pass, you would create a network of practitioners who are sympathetic to the principles of assisted dying, and therefore will understand that when somebody comes forward to say, I want to die, that they will be more they will be more receptive to those ideas that the individual has, and therefore will facilitate their process through this, which I think undermines then any attempts to have objective scrutiny of coercion that may occur. There's nothing that stops you from saying, well, I know that there are these certain people I can go to who have either been public or have supported others to have access to the service, and therefore that's my best chance of gaining access. And I think that then collapses all attempts to address issues of coercion.
Thank you for your question. I would add to what Mira is saying to say that what we've seen in our study is a more subtle form of influence, and sometimes it actually comes tragically from the clinicians themselves. We saw 95% of clinicians tell the patient and their family that they had an incurable, irremediable illness with a 6-month or less prognosis in some cases. And that has an influence on a person. And I have to say that does not cohere with the evidence on eating disorder recovery. In fact, we have no good ways of making prognosis in eating disorders. The only good prognostic indicator we have is weight restoration. I would also highlight, relevant to here where we live, that the APPG just put out a brilliant report on huge gaps in the care system. I'm working with a person and a family right now who's been to the Court of Protection, whose eating disorder team presented her and used the term not treatable to the judge, and used the term in the end stage of her illness, and predicted that she would die within 6 months. 18 months later, she and her family are still fighting for treatment and are being denied services. So that is the kind of coercion I'm worried about, is the kind of coercion that happens within a healthcare system that I know many of you were elected to fix. You know, that's what so many people are called for, is fixing a broken NHS. And that's not my choice in terminology. I love the NHS, but I think that's what we need to be worried about, is especially in clause 4, subsection 4. That to me reads like a formula for coercion. If a physician were to say to a young woman with an eating disorder, you have a severe and enduring eating disorder, which you will not find in any diagnostic text, but is used frequently in these cases and in the court of protection. We have done all we can. The treatment options are exhausted. Again, you will find that in the court of protection. Your prognosis is poor. It leaves you with a feeling that you have nothing left to choose from, especially if you're struggling to access services.
Thank you. I mean, no discourtesy to the committee, but we have 20 minutes, and 10 members wishing to ask questions. So we have to move this on, I'm afraid. Rachel Hopkins.
Thank you, Chair. Can I ask Mr. Amin about his views on coercion, particularly in light of Clause 2 in reference to the Mental Health Act and the Mental Capacity Act, and any thoughts you have, particularly on the groups you represent, about that?
Well, as I said, I've worked in this area for over 20 years. I represent individuals week to week in this area, and safeguarding is all across what's needed for these individuals. And when you're talking about professionals who are involved in their lives, they're regulated. So we're talking about doctors here who are meeting individuals, and they understand what it means to identify safeguarding triggers and where referrals are required. So I think that makes it quite strong in this particular act. The wording, as you've got it in the act, I'm comfortable with. And I say that as someone who's worked in the area for many years, and lawyers will go to court and pick over words, but I think the way it's drafted, it's understood that there is voluntariliness as described within the bill, and coercion. I don't think additional words are necessary to describe what's required here. It's a voluntary free will decision, and coercion's defined there. So when we're talking about a doctor trying to understand that and a court then interpreting it, I think it's pretty clear what that is. So I'm comfortable with the way it's drafted. Generally, on a safeguarding perspective, as Tom has said, there's a number of points at which professionals are asking the individual for the decision here over a number of weeks, goes into months. So it's quite a robust process here. And I point also to my note, footnote 3, paragraph 4 of my note, where I've referred to the current existing law outside of the Court of Protection, where it might be thought that the person has capacity, but there's concerns about coercion, etc. There is, under Section 42 of the Care Act, the provision for safeguarding referrals. There is, under Section 222 of the Local Government Act, provision for a local authority where referrals are made to bring the matter before the court under the inherent jurisdiction. And the inherent jurisdiction doesn't go away. It's here and available where there are concerns for safeguarding of an individual, to allow them to make their own individual free will decision. It's not there to do anything other than protect the individual and have a safety net around that individual to make individual autonomous decisions. So I think nothing needs to be tinkered with, I would say, in the current Act, because that is there. Parliament's already provided for that. Have I answered your question?
You've given clarity, thank you.
Thank you. Julian Campbell, please.
My question is to Professor Shakespeare and to Dr. Griffith. In Section 4 of the bill, it offers the opportunity for clinicians to be the people who instigate the discussion on assisted dying. Could you both tell me your view on that, please?
Thank you. Professor Shakespeare.
I think that it's natural and right that somebody should discuss their wishes with the doctor who supports them and treats them. I don't think there's a problem there. I think Marie, her suggestion that there should be a wider body to look at this is very relevant. And I also think that doctors at the moment refer people for abortion, women for abortion, and that does not stop them also supporting pregnant women. And no, I don't think women would, distrust their doctor because they're sometimes involved at some point with the abortion decision. I think it's quite obvious, and it's, as my colleague said, in the bill, what is a terminal illness and why we should support you voluntarily to exercise your choices. And I think, lots of doctors will not be in favour of this. I think they will be clinically professional. They will discuss with the person. I don't have a concern about that. I think you're more likely to be kept alive against your will than you are to end your life under this Act.
Sorry, Chair.
Dr. Griffiths.
So I think my first point would be it raises concerns because it relies then on doctors' interpretation of prognosis. So if a doctor assumes that you have 6 months left to live and is therefore then going to start having a conversation with you about the possibility of suicide, I think that then draws into question how we are allowing then this assumption made about if an individual does have 6 months left to live, and particularly when we have evidence that shows that with certain interventions and also certain mishaps surrounding prognosis, individuals can live for months and for years and decades longer as well. So the idea of bringing in the conversation from the point of view of the medical practitioner could arguably accelerate one's death. If the idea of prognosis was taken into account, that their idea of prognosis may be flawed. It also, I think, raises problems because we know that many individuals, and whether we want to create this false line between disabled people and people with terminal illness, irrespective, individuals with health conditions and impairments do not have access to advocacy, do not have access to a representation in processes such, for example, in this kind of process. So therefore, having a conversation where there is extreme credibility and validity that rests on the medical practitioner could, I think, exacerbate issues around coercion as well. But also, I would just like to add as well, for me, I think we could take a moment of reflection. For example, when we were going through the pandemic, the Parliamentary Health and Social, the Parliamentary Ombudsman for Health Services highlighted how the interpretation of medical practitioners to think about the use of do not attempt resuscitation orders and how that was utilised within the disabled people's community, I think has parallels with the issue we have here where medical practitioners will be making assumptions about whether conversations or applications should be made.
Thank you.
Can I just raise one point on representation, just following on, is just point members to paragraph 10 of my written submissions, which tries to make the important point that if we're involving courts, individuals need access to justice, they need access to advice, and that means legal aid. And so I point in that paragraph to the provision for non-means tested legal aid, just like parents of children where withdrawal of life-sustaining treatment. Those current rules are in place for parents, and a similar arrangement could be put in place for individuals who are brought before the court in this matter.
Liz Saville-Roberts.
Because we have England and Wales as a single jurisdiction, but health's devolved, and we have been discussing an amendment, it appears likely, to Clause 12 in relation to the court of a multidisciplinary eligibility, something or other, as opposed to a high court. What are the implications for us to understand as a committee in how this plays out with health being devolved, but the jurisdiction being single?
When we're talking about a legal panel, I mean, if the legal panel is not a High Court judge, but it is a multidisciplinary panel, then it just draws upon the people in the local areas. So when it comes to the Court of Protection, that operates in England and Wales, and the judges apply the law the same way, and that's what the panel would do in this case. Are you more concerned about the makeup of the panel or how they apply it?
What I'm trying to tease out is what is the responsibility of the Senedd and what is the responsibility of the UK government, because this is going to be challenging given that health is devolved and has been for 25 years.
Well, the responsibility for Are you talking about responsibility for resourcing it, or
Who has to decide who is appointed to what? Which body?
Oh, I see. Well, I suppose if there is a multidisciplinary panel, then the judiciary would appoint the individuals going there, and the it would be a judicial body essentially. I don't know if you're talking about a tribunal that's multidisciplinary, although I know people shy away from tribunals.
I think there is a question, because we are a private members committee, as to how we ascertain these details. But thank you.
I think that is a matter that we may have to pursue elsewhere. Nasha.
Thank you, Chair. I have a quick question for Dr. Griffin, and then if I can move to Chelsea. Dr. Griffith, how does the bill exasperate issues for disabled women in particular who might be experiencing abuse or other vulnerabilities?
Well, there's no indication of how you would place the infrastructure for support for people who may be having whose discrimination or their exacerbation of injustice exacerbated through an intersectional lens. For example, the cross-cutting of different experiences, how that can be attested for within the bill. So, for example, there is no infrastructure for if an individual comes forward to discuss with their doctor about the concerns that they have, how that will be acknowledged from an intersectional critique. I think there's also concerns here about the way in which we know that many people within disabled people's communities from particular backgrounds, such as women, for example, are pre-exposed to further levels of injustice that are not accounted for, and that their experiences of trying to access support or trying to access support for certain aspects of their life are compounded by inequalities, and therefore these issues aren't addressed by the bill. And what you will have, in my view, is that you will have individuals who will, if this mechanism becomes available, the issues that they face in terms of injustice will play into the consciousness of their decisions to go forward with this. And I can't understand any clause or any amendment that would address that issue in its totality.
Thank you very much, Dr. Griffiths. Just before I move on to Chelsea, just to point out that Professor Shakespeare, you've said that most organisations support this, disabled people support this bill, but actually only one organisation, one DDPO, has opposed it, is giving evidence. So I just wanted that point noted for the evidence in particular. Chelsea, coming back to yourself, thank you for your evidence. Eating disorders are classified as mental disorders under the Mental Health Act, and this bill explicitly states a person cannot be considered terminally ill only because of a mental disorder. You've also talked about the withdrawal of insulin. Could you respond to both of these? Why do you believe eating disorders would still meet the criteria under this bill and the issue of insulin, stopping insulin in particular?
Ms. Roff?
Yes, thank you. I would draw an underline. There's a false distinction being made between a mental disorder and its somatic or its physical manifestations in this bill. Mental disorders, especially eating disorders, not just anorexia, impact the body, and they have life-threatening consequences. We had 20,000 acute hospitalizations for eating disorders in this country last year, and we have, again, massive gaps in care. And those are individuals who, if they were to choose to forego treatment, would qualify under this bill or could not access treatment because they're on wait lists for a long period of time. I would draw your attention to the evidence I submitted with Dr. Agnes Ayton, who's at the Royal College of Psychiatrists, Dr. Angela Garda, a leading physician from Johns Hopkins University, and I would also draw you to our own case law, the Court of Protection, where we've had physicians represent eating disorders as terminal conditions, as in the end stage of their illness. And then I'm grateful that you've drawn the connection to diabetes, because it's not just about eating disorders. Substance use disorders would have this same effect, and outside of mental disorders, HIV/AIDS is a progressive condition that cannot be reversed by treatment. Are you okay with a 19-year-old young man who decides to discontinue treatment qualifying under this bill? Those are the questions you have to ask. I'm not in principle against this bill, but you have to look at the letters on the page because they will be interpreted after the bill is passed and your constituents are depending on you.
I'm sorry, we still have more members and more questions than we have time, so I'm going to come down to one question per member. Kim Leadbeater, please.
Thank you, Chair. Thank you for coming and giving evidence this morning. It's incredibly helpful. I'm going to come back to clause 2 of the bill, the definition of terminal illness, because I'm very clear who this bill is aimed to help and who it is not aimed to involve. So the definition says that the person has to have an inevitably progressive illness, disease or medical condition which cannot be reversed by treatment. It also says, for the avoidance of doubt, this cannot be a mental disorder or a disability. So what I'm really keen to know is, because I hear your concerns and I want to support you and work with you on this, what else do you want to see in the bill that would reassure you that this is not about disabled people and it's not about people with mental disorders?
Well, I'm conscious of time, so I'll be very quick. But I suppose my first point would be, why would you stick it at 6 months then? Why not have it at 7 days, for example, as a way to take out the issue concern that we have? Because we're talking about, if you're talking about prognosis, going back to Chelsea's point, going back to the point that I made before, our condition, my condition is a neuromuscular condition. I have had meetings with clinicians where some have referred to it as a terminal illness, some have referred to it as a life-limiting condition, others have referred to it as a progressive condition. So the articulation of the ideas and the ways in which we think about conditions, again, I think shows the complexity that we are talking about disabled people, and terminal illness and people who are terminally ill do constitute as disabled people under the clauses of the Equality Act. So you cannot make the distinction. And for me, I think if you wanted to be quite proactive about it, then why not reduce the prognosis time frame to make it as short as possible, to take out the concerns around prognosis, to take out the concerns around if individuals are going to live longer, or they could be facilitated access to alternative treatments to prolong life. I don't understand why we are fixated on the 6 month prognosis, because, and again, what we've seen in other countries is as soon as you pass it on 6 months, you will have individuals who would say, why not 7 months? Why not 5 months? And then you'll have campaigners who will say, this doesn't include me and I've been campaigning for this. So there will be a pressure to change. And governments will change. So there's no guarantee that you can make that the eligibility criteria will be fixated.
Danny Kruger.
Thank you. I just wanted to give Professor Shakespeare the chance to respond to the point that we've heard. I'm just interested, Professor, if you recognise that many disabled people would qualify as terminally ill under the terms of the bill, and what protections we could give to prevent that. And in fact, not just disabled people, but anybody who declines treatment that keeps them alive.
Well, thank you very much. Thank you, Chair. First of all, I mean, the terminal illness is defined as a condition which cannot be reversed by treatment. And I know that that isn't a cure. You're not aiming at a cure, but it cannot be reversed. So surely that would include things like HIV and diabetes, because they can be reversed. They cannot be cured. They're still there, but they can be reversed. You've got insulin or antiretrovirals or whatever. I think, yes, terminally ill people are disabled people almost always, but that doesn't mean that all disabled people are terminally ill. And even if you have a disease or a condition like Miro or like other people, which will probably result in your death, eventually you're not going to die tomorrow or in 6 months. You may die in 16 years or whatever. And I think it's very difficult to define terminal illness. And that's why 6 months, I think, is used in the Act. If it was a week, I mean, how many... I remember very recently, my aunt died. She was unconscious for the last month or so of having cancer, and then she finally died. She would not be able to express her will and her preference to have assisted dying, even if she wanted it. Therefore, I think 6 months, when you can be in, you can have capacity, you can anticipate, you know you're going to die, but you want to have control of the manner of your death. I think that is more useful than a 7-day or less when you might be unconscious and you might not be able to express a will or preference about it.
Simon Ofer.
Actually, my question has been asked by the honourable member there.
May I respond briefly?
Briefly, please.
Thank you. I want to address your question, and I know it's not your intention for eating disorders to be included in this bill, and I'm grateful for that. When I started our research, I thought we just need stronger safeguards. That was where I began. And after looking at 33 jurisdictions around the world, I have real doubt about whether safeguards, I know how difficult it is to put it on the page, and I'm seeing it expand and be applied through interpretation. I would disagree respectfully that diabetes is a reversible condition. You cannot go back in time and reverse that condition. And I would also just really emphasize to all of you on the committee that the question before you, you are doing this for a noble purpose. I agree, and I have members of my family that want this to go through. And yet, the question before you is, could this bill have knock-on effects that affect some of your most vulnerable constituents? And how many deaths are you okay with? That's really, if the safeguards fail once, that is a human being who maybe in a despairing moment was handed a lethal medication instead of the care and the treatment and the health they need. That's what we're talking about. So you really have to get this right, because those people are depending on you.
Lewis Atkinson.
Thank you. Can I ask Mr. Amin in particular for your view, given your expertise in representing these cases towards the court, around particularly the mental capacity issue, Mental Capacity Act issue regarding eating disorders and other disorders. Obviously we've heard one version of that. In terms of your experience of working with UK law to the highest level, what your assessment of that is?
Yeah. I mean, I have worked in a range of medical treatment cases over many years, so different illnesses and conditions, and Section 2 to me reads fine. It works. It's clear. I don't consider it needs any additional words, and I can understand when we go to court, cases will come through and they'll fall within those definitions, and it'll be clear. From anorexia, I mean, I don't consider it to be coming into a terminal illness unless it's right at the end of life, and that doesn't really fit within the parameters of this Act, because we're not talking right at the end of life. And then you've got the Mental Health Act, Section 63, that deals with anorexia, where there's force feeding that clinicians consider. So, I mean, that's my view on the anorexia side of things. And I think doctors will provide the evidence on terminal illness. And you've heard from the Chief Medical Officer yesterday, and they're going to provide guidance around all of that. And subsequent to this Act, there'll be the secondary legislation and then the guidance. And they will provide that clear guidance, which will then feed into this, and the evidence that will be before a judge that says, yes, it is a terminal illness and the prognosis, etc. So it's nothing different to what we produce in medical treatment cases before the court at the moment, where the doctors produce expert reports and give evidence, explain the condition, explain the prognosis, explain their decision on capacity, and explain what's in the best interest of an individual if they lack capacity. That's, as I understand it, how the Act is crafted to produce the evidence as you go along the path here and then eventually to the judge.
If I made just one sentence, because it's related to eating disorders, I would refer to a 2012 Court of Protection case where a 29-year-old with anorexia was described as in the terminal stage of her illness, where the physicians, multiple physicians, described her death as inevitable. And I would also refer to a 2023 case seen at the Court of Protection where a young woman, where it said, I recognize with deep regret that it will probably mean that she will die, and she was described at pre-death stage. And that young woman, again, is still alive and still fighting for services. So while I respect what you're saying and I agree with your interpretation, we have case law in the UK where people with anorexia are being found to be terminal. So we've got to take that reality into account.
I don't think they were found to be terminal, but they were described by a doctor in a case that they were terminal, and that doctor may not have described it properly.
Indeed, but a judge will be
Thank you.
relying on
Thank you. This will have to be the last question. Jack Abbott, please.
Thank you, Chair. My question for Mr. Amin. You worked on the judicial review of Noel Conway in 2018, and for the committee's benefit and those watching, Mr. Conway had terminal motor neuron disease, and he looked to bring a judicial review in order to have the option of assisted death when he was in the final 6 months of his life. Mr. Amin, what were your kind of experiences from that case which may inform our learnings as part of the committee when we're looking at the bill?
Well, Mr. Conway was an extremely intelligent, brave individual who campaigned in this area, and his strong view about autonomy has brought him to bring that case, and what he was arguing for in that case forms part of what you've got here in the bill. So he was certainly asking for a process where a decision can be made and some robust safeguards can be provided so that which would end up with a court process, and that's what you've got within this bill. I've also learned through that case and through other cases over the years what the Human Rights Act means here and what the European Convention means here, and parliamentary sovereignty. So on all three counts, the cases have always said that it's Parliament that makes the decision, so it's you that's deciding. I don't see a court overturning that, and the courts in the Conway case, both High Court, Court of Appeal and Supreme Court, were all very clear that it's a matter for Parliament. I really don't see European Court of Human Rights overturning in any way at all, and that's my long experience. The margin of appreciation is very strong with this Parliament to make the decision. And I also think from a drafting perspective, what the bill does is very carefully define the individuals. It's drawn the line. And certainly the courts cannot do it. The courts cannot extend that line. The courts will always defer back here to Parliament. So if you craft this Act as it is,
Order.
Very confident that it will be.
I'm terribly sorry, we're out of time. Off the record, because I think we're now off the record. Yes, please.